It's my privilege to welcome back. Actually, the first person that I ever met from World of Lubin, who is a long-standing member of the ISP family, but is also professor of law. I'll be official in a few months. He's currently associate professor of law at Indiana Law School. It's such a privilege.
Thank you. So it's a real privilege for me to be here too, because what I'm going to talk to you about really has its intellectual origin story right here in this building. I would walk through Old Campus and pass by the statue of Nathan Hale nearly every single day. Hale, for those who don't know, is a Yale College graduate and a former spy for the Continental Army in the Revolutionary War. He is known for saying in his final words as he was convicted for his espionage and harm. I only regret that I have but one life to give to my country. That's inscribed on the bottom of that monument. And those words very much reflect the kind of values that we were imparted when I worked in the intelligence community. In respect, it represents a past that I don't necessarily tread in quite the same way today. But Yale also honored me with the Robert L. Berenson Human Rights Fellowship, which I completed at International in London from 2016 to 2017. And that year was a profound year for me. My job entailed assisting the legal team at Privacy International, writing legal memos and briefs to international human rights organizations and courts, challenging the legality of certain corporate and governmental spying. So with Nathan Hale's creed on the one side and my newfound friends on the other side, what I emerged as is a staunch defender of centrism and pragmatism in a space that is, by design, more akin to speaking at the edges rather than in the center. And so in thinking through how best to start this talk today, I thought I'll start with a story because it's espionage. Espionage is known for its stories. So here's the story. Our story begins in Addis Ababa in 2012. That January, the African Union unveiled its new headquarters, a $200 million architectural marvel designed and constructed by China as a quote-unquote gift to Africa. The building was meant to dazzle, and it did dazzle. A 20-story granite-clad tower rose above the city, its vertical fins cutting sharp lines against the sky. Beside it stood a vest-shaped dome, the one you're seeing on screen, housing the plenary chamber, bathed in light from the soaring atria that gave the complex an air of openness and an air of transparency. Yet transparency that was promised by architecture did not deliver by the life of the walls. And that is because in January 2018, Le Monde Afrique revealed that the building itself had been listening. For nearly 5 years, every night between midnight and 2 a.m., networks within headquarters had quietly transmitted confidential data, internal reports, diplomatic cables, records of meetings to remote servers in Shanghai. A subsequent technical sweep of the building uncovered recording devices embedded in walls and tucked in the furniture. The architectural symbol of African sovereignty had, it turned out, been fitted with its own surveillance system. Both Beijing and the African Union moved quickly to smother the scandal in denials. Officials dismissed the reports as absurd, unfounded, and designed to sow discord, while insisting that relations remained exemplary. No formal protest was lodged. The public line emphasized the durability of the partnership, and journalists who pressed too hard were quietly discouraged. Yet backstage, the tone was very different. The African Union replaced Huawei-supplied servers, tightened internal cybersecurity protocols, firmly declined Beijing's offers, the audacious offer to reconfigure the system for free. Chinese officials made no admission of culpability, but were quick to remind audiences that, quote, all partnerships have ups and downs, end quote, while reiterating their commitment to what they now called, quote, African digital sovereignty. By 2019, the African Union signed a fresh new memorandum of understanding with Huawei, this time expanding into cloud, computing, and 5G. A senior official from the African Union later admitted that, quote, the situation was managed internally, and that at the end of the day, no one wished to jeopardize a partnership considered strategically important to fail. The scandal, in other words, was absorbed rather than confronted, handled backstage, denied on the front stage. I think this story tells you something about espionage scandals. So when covert operations come tumbling into view, as they so frequently do, states do not reach for statutes. They reach for scripts. These scripts include moments of pearl clutching and strategic ambiguity, a diplomatic facade filled with crocodile tears and deflection of both facts and accusations. Law may be invoked at times, but more often it functions as a smokescreen, preserving operational and diplomatic flexibility. After all, in the great game of espionage, dispute resolution is rarely a matter of principle and more often a matter of performance, an elaborate spectacle staged to appease external constituencies while absorbing the political shockwaves of the scandal itself. There's a good line for it. It comes to us from Cold War CIA analyst James Angleton, who masterfully described the labyrinth world of spycraft as, quote, a wilderness of mirrors. It is a realm where truth is refracted endlessly, concealing more than it reveals. Now, to many formalist international lawyers, everything I just told you is an aberration. It's a distortion of the rule of law. One critic has gone so far as to describe these theatrics as, quote, a form of legal schizophrenia. This presentation and the book from which it draws argues that this so-called schizophrenia reflects not law's breakdown, but its adaptation to conditions of secrecy and the exigencies of national security. But to see that, I need to take us backwards and start with the basics. And nothing is more basic than the very thing that we're talking about. What even is espionage? Part of the problem is that there is no well-agreed upon universal customary definition of the thing we're talking about. And so for today's talk, I'm going to offer a working definition. And it is just that, a working definition. There can be many definitions, but it's one that is meant to count discussion around something we can all agree on. And so my definition has 5 parts: peacetime, passive, cross-cyclical, interstate, and clandestine. By peacetime, I simply mean that I'm not dealing with wartime espionage. We can talk as much as you want about wartime espionage. I am fascinated by the subject as much as you might be, and yet that field is regulated by a set of regimes that has explicitly addressed espionage in ways that the peacetime espionage has not, and therefore generating more interesting questions to ask about peacetime. It is also the case that most espionage occurs in peacetime and therefore generates a more interesting case study for us. When I'm talking about passive, I'm simply excluding covert action. Now, covert action is a term defined under US law. Other countries have called it differently over the years, like influence operation or manipulation operation. By that, I simply mean not just the act of collecting information, but the act of deleting information or changing the environment in which you operate. And in the more extreme circumstances, assassinations, regime changes, kidnapping leaders from Venezuela. Those sorts of things are not the subject of today's discussion, even though at times they are carried out by the same sets of actors, okay? And we can have a conversation in Q&A if you're interested. Is it fair to separate those two? I will tell you there's academics who think it's not fair to analyze the law on intelligence, passive information gathering as distinct from the law of covert action, but I will do so for today's presentation. When I talk about pro-cyclical, I simply mean that I'm looking at the entire intelligence cycle. So that is the picture on this right side of the screen. I am not only looking at the mere act of collection, which is where a lot of the international legal analysis is focused on. Is it lawful to collect this piece of information in this way? There can be really interesting international legal questions about, is it lawful to share that information? Is it lawful to use that information in a particular way? And in fact, is it lawful to store it in a particular way? And those questions can only be answered if you're studying the full scope of the intelligence activity from start to end. And that is the kind of definition that I offer you today. The fourth is that the operation involves 2 states or more. That is to say, I am not interested in intelligence done by non-state actors. international organizations, although I'm happy to, or international organizations, although I'm happy to talk about those cases with you too. Okay, so I'm only interested in one state collecting intelligence against another state, and by state, I employ the law on state responsibility, attribution rules to define who might be an actor working for a state. And finally, it is clandestine as to both the targets of the operation and the choice of methods of the operation. And so the reason why we need that final element is because if we don't have it, the consequence of that will be that a diplomat sitting in his office reading a newspaper will too be an act of espionage. After all, it occurs in peacetime, it involves a collection of information, it is cross-cyclical, it is interstate. And yet, not all things should be captured under the rubric that I'm calling espionage. We need to narrow the thing that is under discussion. And I put to you that some degree of secrecy as to both the reasons for the collections and methods is necessary for this. But I tell you, there's a 30,000 words chapter 1 for this book that is just about this definition. There is so much that we can analyze just with it. So I'm going to leave it for now for the Q&A. All right. So with that, you might want to ask, what has thinkers said about this topic, about espionage? And the traditional story is often told through absolutist terms between two very absolutist thinkers. On the one side sits Hobbes. Hobbes described, quote, spying is like rays of sunshine into the human spirit. He described the state as a spider and its intelligence agents, its spider webs, feeding the mother spider with information. He said that in a state of constant uncertainty, where every nation state is worried about a surprise attack, a decision not to spy is a dereliction of duty. How dare you, world leader, not spy at all circumstances and in all possible ways available to you? Doing so would mean not meeting your duties to your polity. Your duties are to constantly collect, so you are constantly aware of any threats that might be imposed upon you. That's a Hobbesian way of justifying spying all the time. Hence, for Hobbes, spying is always legal. On the other side sits Kant. Now, Kant believed in a perpetual peace, and he believed that the way to get to the perpetual peace is by instilling trust among the nations. And for Kant, the most disgusting, in his words, diabolical thing to do is to spy. Even more so than to injure or kill, to spy. Because spying is the kind of thing that hurts the egos of a nation in a way that they will never forget, unlike the club stroke on the head. It's the pinch of the needle. And the pinch of the needle of espionage breaks the bonds of trust between the people, and it is those breakages that would deny us the ability to ever achieve that perpetual peace. And so for Kant, spying is always illegal. No matter how you do it, your only solution, transparent information data, collaboration with others, not by means of covert activity. There's the absolutist theory, and that's from one representative of that would be Professor Asaf Lubin. Now, he said, this is from an article he wrote in 2007 in the Michigan Journal of International Law, where he said, mortals should not attempt to perform miracles. We cannot convert water into wine at weddings, turn lead into gold in a chemistry lab, or form a human being from a lump of clay. To accept reality is to abide by the laws of physics. And what are those laws? The espionage and international law cannot be reconciled in a complete synthesis. One starts from the peaceful resolution of conflicts, where conflict was once, where justice was trampled. And the other is about lying and cheating and deceiving. They are antithetical to each other. In fact, he goes on to say that those who wish to engage in research and scholarship on espionage and international law, nay, those who want to write a doctoral dissertation on the topic and then turn it into a book, do yourself a favor, quote, move to other projects with grace. The introduction to my book says, I personally will take the grace, but not the advice. And the reason is because I do think that absolutism make no sense. The absolutist theories don't work. And you don't have to take my word for it. You can take the word of John le Carré. John le Carré, the famous spy novelist, writing in his final 2016 book, in the Pigeon Tunnel Stories for My Life, he talked about the varied motivations and experiences of both spies and spies agencies. And he said, the harder you looked for absolutes in this realm, the less likely you were to find them. There are no absolutes to be mapped cleanly onto intelligence practice, only shifting judgments negotiated under conditions of uncertainty. The good news is that we are not really today still operating in an absolute space. Most academics I know talking about espionage have moved away from absolutist theories, those that say that spying is always legal, always illegal, or neither legal nor illegal, aka extra legal, into a space of relativism. Spying is sometimes legal and sometimes illegal, and the question is just when. And that is been divided into the majority camp, that I will also fight today, and the minority camp where I am located. So let me start with the majority camp. The majority camp consider themselves generalists, meaning that for them, espionage is, quote, not per se regulated under international law. That's what the Tallinn Manual teaches us about cyber espionage. It's, quote, not per se regulated, meaning that you cannot find anything intrinsic to spying that will determine the legality of any intelligence operation, and that instead, to determine the legality of the operation, you should treat it like any other state act and regulate it under Lotus by searching for prohibitive rules. So our job is to search for prohibitive rules in the ether that might regulate particular spying activity. And these books all say that. That's the majority of the literature. They all affirm a generalist account of the international law about intelligence. And I stress that it's about or on intelligence, not of intelligence, because there is no international law of this thing. It is not per se regulated. To demonstrate a core prohibitive rule that regulates spying, they put forward this, a pretty simple graph. I'll try this. Look, we can do red. So on here is the spy vector. We have the human spy, the spy ship, the spy aircraft, and the spy satellite. All of this comes to us from a great book by Fabienne Lafosse, Espionage and International Law from 2012. And over here is the spaces vector. So we have our territorial sea and land and national airspace spaces under national sovereignty, and all those other spaces like international airspace and high seas and outer space under international control. And all I need to do is draw this black line. And then here in the middle are violations of international law, and here outside are no violations of international law. The law is simple. If you're spying in the territory of a state without its consent, you're violating its sovereignty. Sovereignty violations are a violation of international law. The result will be state. If you're spying from outer space, there is a global commons there. If you're spying from the high speeds, there's a global commons here. No one state can claim sovereignty. No violation of international law. It is lawful to do so. Now, they can do that with other prohibitive rules too. So, for example, if you spy from an embassy, you're violating the Vienna Convention on Diplomatic Relations because it says that you cannot use the embassy to spy on the host state. If you're spying from a different location, that's lawful. If you're spying on an embassy, you're violating the Vienna Convention on Diplomatic Relations, which says that the territory of the embassy is inviolable and the diplomatic bag cannot be touched. That includes the correspondent. You're violating the Vienna Convention on Diplomatic Relations. That's a violation of international law. If you're operating in a different context, you're not. So all we're doing are searching for prohibitive rules, and we might find them across all zones of international law, from the law of the sea, about spying submarines, to the law of territorial airspace, the Chicago Convention. So this is the norm. It's very easy to understand. It's pretty simple to apply. Now I'm going to try and convince you that is malarkey. Utter malarkey. The first reason, the most obvious reason, is that it requires us to apply territorial line drawing to aterritorial spaces. And the most obvious example, of course, is cyberspace, but I will prove to you in a second that it's not just about cyberspace. But we'll start in cyberspace. The same African Union, remember, the one that allowed the Chinese to come back, still has an official position online that they've come together with in 2024. My dear friend Muhammad Hilal helped, as the reporter, write this position. And because Muhammad Hilal is such an amazing lawyer, it is the most tight, no way to get around it definition. And here's what they say. The African Union affirms that by virtue of territorial sovereignty, any unauthorized access by a state into the information communication technologies infrastructure located in the territory of another state is unlawful. The obligation does not include any de minimis threshold of harmful effects below which an unauthorized access by a state into those infrastructures will be lawful. There is no exceptions. Anytime you enter my cyberspace without my consent, you're violating sovereignty, you're violating international law. The only problem with that is that that is not a consensus view. So members of the Five Eyes certainly disagree. I gave you the example of Canada, which in its national position had said that some cyber activities, including explicitly cyber espionage, do not amount to a breach of territorial sovereignty and to a violation of international law. And the reality is that even kind of countries that are not in the typical mix, Germany, have equally talked about a de minimis line of sovereignty in cyberspace, below which, where there's no harmful effects, there won't be a violation of sovereignty in cyberspace because sovereignty, it was argued, operates differently in those contexts. But to my point, it's not just about cyberspace. Think about, say, a Chinese spy balloon hovering in Montana. Now, that balloon operated in a space that exists between territorial airspace and outer space. And the reason for that is because we international lawyers have never defined the line for when territorial airspace ends and outer space begins. And guess what? We've also complicated things for the law of the sea, because in between territorial waters and contiguous zones and ICs exists this other thing called the exclusive economic zone, 12 nautical miles, where coastal states enjoy certain economic powers of control and where high sea states enjoy their navigational powers. And we've seen a lot of back and forth where we place surveillance activity within the zone, and particularly when in relationship to the due regard obligation to the rights of the coastal state as protected under Article 58 of UNCLOS. And so there too, China certainly believes that America cannot engage in freedom of navigation operations that involve surveillance in China's EEZ. So what I'm getting at is that there was an assumption here that all of this was really clear and well-defined, except that it is totally not. But there's even more than that. My biggest problem has to do with the current place in time we are in international law. And that is that international lawyers are partially at fault in the loss of legitimacy of the system that we claim to protect. That it is not just about rulers who don't care. That it is also about our responsibility. And by that I mean something that Hans Kelsen taught us in his 1945 book, General Theory of Law and State, where he said that a norm is considered to be legally valid if and only if it exists in a system of norms, an order which is efficacious. A basic requirement for legitimacy is efficacy. If you keep telling me that the sun is brown and I go outside and I see a yellow sun, I start to not believe you. If you keep telling me that spying in the territory of another state is illegal, heck, that spying from an embassy is illegal, and yet every single country does it because it's the cheapest form of spying, and it's because they find spying inevitable, then I don't believe you. Now, formalists will tell me, well, that is just violations to prove the rule. No, it could be that the rule needs reconceptualization to account for its descriptive mismatch with reality. That is also a possibility. And so against this backdrop, the question becomes, if this is not the law, what law governs espionage? And the good thing is that you don't need to take Asaf Lubin's word for it. There have been dozens of books that have been written in the last 30, 40 years, all proposing an alternative account to norms and governance regimes for intelligence. It's just that they've been written by non-lawyers. They've been written by moral philosophers, they've been written by ethicists, and they've been written by intelligence studies professionals, people who grew up from within the agencies. And they've come up with books that build a theory that they call just intelligence theory. And the name should harken familiar because it sounds a lot like I'll skip that because it sounds like that, just war theory. Now, just war theory, of course, not new. Origins in Christianity. Saint Aquinas coming up with a theory for why it is lawful to engage in uses of force on behalf of the church, and then engage in territorial acquisition in the name of God. And they build a whole regime around a just cause carried out by a valid authority and so on. But all of that was then later secularized, some of it written by people in this building, like Donna Hathaway and Scott Shapiro, secularized into a legal regime on violence, which we today are all familiar with. The law on the use of force, use ad bellum, the law during war, use in bello, and the Geneva Conventions, and the law after war, state responsibility and international criminal law, use post bellum. And that regime was codified, and it was codified because we know that the ICJ has already told us, and that was that quote there, that in the Southwest Africa case, that a court of law can take account of moral principles only insofar as these are given sufficient expression in legal form. So if you write a series of books about the ethics of espionage, the ethics of espionage do not get translated into law in the absence of a legal codification of moral rules. But the good news is that there have already been acts to codify that thinking. So the European Court of Human Rights, in a very famous case called Zakharov v. Russia, one of the first mass surveillance cases, but in a domestic context, had said that review and supervision of secret surveillance may come into play at 3 stages: when the operation is first ordered, while it has been carried out, and after it has been terminated. Before, during, and after, usad, usin, uspost. That is exactly what those scholars are saying. And only that they're building themselves on moral theories, namely, what is the justification to engage in intelligence, and how do you conduct it for each operation, and what do you do afterwards? And what Zakharov says to us, how can I apply the right to privacy in a legal concept to account for all those temporal stages during an intelligence cycle? And so if we combine the two, try to infuse moral theory into our existing conceptualization, grounded to a great extent in human rights conceptions, you start to imagine a world of use ad explorationem, use in exploratione, and use post explorationem. A law for launching intelligence gathering operations, a law during intelligence operations, and laws for recalibrating espionage once those are exposed or ended for some other reason. And what I would contend to you is that we already have this law as a matter of customary international law. And so what I am suggesting in this book is that there are a set of very fundamental macro level necessity, proportionality, and efficacy standards and micro level necessity, proportionality, and efficacy standards to govern the entire campaign and each individual intelligence activity within a campaign. And that if you don't agree with me that it has emerged as customary international law, my alternative, maybe it has emerged as a general principle of law under Article 38.1c of the ICJ statute as opposed to Article 38.1d, and that in any event, in certain cases, it has been codified into treaties. So the thought that there can be treaties about spying, there are treaties about spying, both in the context of non-proliferation regimes that set out also requirements for monitoring and compliance, but also the Open Skies Treaty that codifies a right to spy in the airspace of another country under the conditions set out in the Open Skies Treaty. What those regimes do, and I will say it in one sentence because it's very meta theory, but I'll say it in one sentence, is that it takes a liberty right under Feldian terms, this is a theory, liberty right, and makes it a claim right. In a liberty world, when I have a liberty, you also have a liberty. In a claim right, when I have a claim right, you have a duty. In intelligence law, we're all liberty. I have a liberty to spy, you have a liberty to stop spying. If I have a claim right to spy under the Open Skies Treaty, you now have a duty to let me. So we codify upwards. Guess what? We can also codify downwards to a no spy. Five Eyes are not allowed to spy on one another. If you set an agreement that says that I have a duty not to spy and you have a duty not to spy, and it's a prohibition or fund set out by that regime. Now, I play three-dimensional chess with a lot of your colleagues, including one that I just come from Harvard. My dear friend Inaki Navarrete has written a lot about this stuff, very doctrinal, very formalist. And he tells me, no, you call me malarkey, you're malarkey. And so here's some of our exchanges so you know them. So my first argument is the international law of intelligence that I've just laid it out is embodied in customary or emerging customary international law. He says that's wrong. He says that's wrong. Not just him. Russell Buchan says that's wrong. Michael Schmidt says that's wrong. I'm just going to name people who apply formalism. Why? Because custom cannot form from secret state practice. If it's secret, if no one knows about it, it cannot generate an iterative exchange. If it cannot generate an iterative exchange, it cannot generate a custom. So I'm going to give you a quick one-liner and open it up for Q&A for why I think that is a wrong statement. But just my one-liner that I do with my students, I'm going to tell you a secret right now. And I want you to react as if you're being told a secret, which is an awe and shock, because that's what people do when they're told secrets. So here's the secret. Israel has nuclear weapons. No shock? It's because that secret, while a secret, Israel has never admitted to having nuclear weapons, is a very shallow secret. The question is, what does shallow secrecy do to law? How should the law account for different layers of publicity? How do we reject binaries to just tell you, if it's a secret, it cannot generate law? No, different things are known in different levels. And the different levels of knowledge could produce different things. And the same is for the law of espionage, but I will take it in Q&A because I don't want to waste too much time. The alternative argument I make is the ILI is embodied, if not in custom, in general principles of law, to which I'm told, what is a general principle of law? We don't know it, we don't understand how it works, we don't know how it applies, you can't use it, it's a source of law that has been there forever, but its application has been mired with confusion, even after the International Law Commission has produced its document recommending particular ways to identify general principles and apply them. And so the book also has a final argument, which is built on this building, which is, if we're playing three-dimensional chess and I keep losing, it could be because there's a problem with the board. The board is set up against me. And that is because espionage as a field rejects the rigidity of binaries. Espionage exists in a liminal space. It's between hard power and soft power. It's offensive and defensive. It's aggressive and peaceful. Espionage is about speaking at different registers for different people at different times. The complexity that it generates into our legal thinking requires our legal thinking to queer itself. And so what I see the New Haven School as, and this is part of the problem, that there's been so many New Haven School people over the years with different theories of what the New Haven School is, but my version of the New Haven School is that it's a queer critical school. It is about queering our understanding of what law is, reconceptualizing law to account for different kinds of norms, not just formalistic, rigid, the rule book of Article 38, to allow for different actors to speak and shape the law. That is a version that maybe is different than the one McDougall had, probably. But it is nonetheless echoing the same ideas about law and society that were at the heart of the project. And so I would put to you that a New Haven School theory is a better theory to regulate these spaces. And with that, I have examples, but I want to, so if there's no question, I'll give you the examples. So how do I apply this framework to case studies? But before I do that, we can just start it with questions. Say your name.
My name is Florian. I'm an LLM student here. Thank you so much for your presentation and your insightful thoughts about cyber espionage. I want to ask, so you say that international law of espionage is an emerging customary international law, but if this has been going on forever, why would it only be emerging now? Why hasn't it been there forever?
Beautiful question. It's tied directly to cyber espionage. I could not have written my doctoral dissertation in the 1970s. I could not have written my doctoral dissertation in the 1980s. During the Cold War, most states were not speaking publicly about their intelligence gathering activities. Certainly, they were not legislating it into their domestic legislation. Certainly, they were not saying that they have a right to engage in foreign intelligence gathering. Part of the way to prove the existence of custom under the doctrinal theory is to suggest that there's sufficient state practice with a sense of a legal obligation. We needed more countries other than just the United States after the U-2 spy plane incident of the 1960s to opine that there is a right to engage in these kinds of cross-territorial, non-consensual intelligence gathering activities in peacetime. In the age of cyberspace, countries are far more public about their, in particular, open source and signal intelligence gathering activities. And in doing so, they are generating visible, and thereby produces an iterative exchange, sort of, a discourse that could generate custom. And so that is the reason why I would even go further to say it has codified into custom. But again, these are all my alternative arguments. In the alternative, it is at least an emerging custom. And then I put it to my formalist friends, how many more countries erecting intelligence agencies with foreign intelligence gathering capacities, acquiring spyware technologies with foreign intelligence gathering capacities, would you need to say that there is state practice coupled with a sense of a legal obligation to do it? And that is to them. They keep saying, well, that's just how many, I don't know, because there's never a definition of the ICJ, but it's on you to prove that it has emerged. It's not on us who has the burden.
I want to engage on the thing that you said about it went from Aquinas saying we have a religious obligation to attack to Ona Hathaway making it secularized. Since the start of that international legal order, now the primary way to get a lawful war going is self-defense, right? And so would you make a distinction between spying that is done in order to ascertain targets, to preemptively strike, versus spying that is done defensively in order to preventatively defend? And the top example I have in my mind is when Joe Biden came out to the country and said, we have secret intelligence that Russia is about to attack Crimea. And then they delayed the war for a few months by coming out with that intelligence.
Right.
That a normative difference.
All right. So the formalists were like, Asaf, you're telling me there's a descriptive mismatch. There isn't a descriptive mismatch, because the reality is that all of this is the law, and then there are exceptions, right? Articles 20 to 25 of our CIWA talk about circumstances precluding wrongfulness. So they come and say, maybe the law is sovereignty, but if you have a right of self-defense, that intelligence gathering for these purposes are lawful as a circumstance precluding wrongfulness. So we can authorize, legitimate a section of intelligence activities that are done in that service, and you can do the same with, say, the exception of necessity, which might also authorize particular intelligence activity. And then their favorite, of course, if the UN Security Council authorizes it, of course, that's also fine. The problem, I fear, is that that is not capturing the big circle. Right now, in every US embassy, there is a CIA attaché. That includes territories against which we don't have any reason to assume tomorrow we're going to engage in any kind of armed activities. No reason to assume that an armed attack is imminent in any manner, even if you believe in a theory of anticipatory self-defense. And so the ability to justify, say, the ability to collect intelligence on an ally, not just a foe, under theories that have been developed in intelligence studies that say today's allies is tomorrow's foe, and also that in the interest of the international system, to increase the cooperation with the ally, you are more likely to sign into riskier treaties if you know what they're doing. And so under that logic, it provides you a pressure valve for coming into more dangerous treaties to your national interest if you have ways to ensure no one is violating. Under that logic, we need to allow a broader set of intelligence activity that extend beyond just self-defensive measures. And so again, you should know that is the big defense for the formalists, saying to me, see, we can authorize a lot of the things you're worried about. I don't think it will cover nearly as much as what is happening in real time.
Thank you. This is so fascinating. I do have maybe it's a provocative question.
Provocative is great.
So what's your ideal, I couldn't fully understand, what's your ideal legal order that you're striving for? And what would be the implications of that order? Because if I'm taking this little black line here, and intrusion into a territory is now legal, then what are we left with? And maybe it's okay that we prohibit it just for the sake of other legal orders, not only international.
Got it. Okay, so perfect question. So first of all, in 1973, those trio, McDougall, Lasswell, and Reisman, write an article called Intelligence Function in Public World Order. In there, it's a very long article written in a very New Haven style writing that you need to read 7 times and you still don't understand what it says. But in there, there's a paragraph where they say, the mere intrusion upon sovereignty should not be the ipso facto basis on which you determine legality. And so the point isn't to say that the breach of sovereignty should be immaterial to the analysis. There's a breach of a well-recognized norm, an intrusion upon that norm. But whether or not that breach should rise to the level of a violation that triggers state responsibility, I think needs to account for other factors too, such as what is the purpose of the operation? What is the context of the operation? Will it is likely to achieve the aims for which it is sought? Is it necessary in the circumstances? Are there least intrusive means of achieving the same aim? That is a multi-factor analysis, the kind of analysis that international lawyers in government engage in, day out. And it is more, I think, reflective of the kind of decision-making that builds into ultimate decisions. The other interesting part has to do with the third prong, so fine, there might be an answer. But then the question is, what does a lex specialis regime of intelligence, which is what I'm proposing, doing in terms of the secondary rules, not the primary rules? And the answer there, too, is that the benefit of calling it international law of intelligence entails a more complex story of remediation than traditional stories of remediation. So that even if there is a violation, the answer is not necessarily obligation to compensate, assurances of non-repetition. No, I'll give you proof, okay? If we look at the United Nations Convention Law of the Sea, and there's a submarine that is existing in territorial waters is refusing to surface with its flag. Under the law, it's engaging in non-peaceful navigation, but the powers of the coastal state vis-a-vis it is only that they must order it to leave, chase it out. Under the Vienna Convention Law of Diplomatic and Consular Relations, if an ambassador spies, the only thing a state can do is not enter the embassy or arrest the ambassador. They can just declare him persona non grata and chase him out. What you're seeing once you're connecting the threads is that there is a law of espionage that treats these kinds of cases alike and produces a different remediation system in cases of abuse. It treats a particular regime around liberty relationships, whereby I am authorized to do what the law has granted me to do against your spying activities. So just to understand that liberty stuff, imagine I'm standing in the street, I'm smoking, and you come next to me waiting on the bus, and you don't like my smoking. I might tell you I have a right to smoke here. That would be wrong. You have a liberty to smoke here. But the law also grants me a liberty not to suffer your smoke. Now, I cannot punch you because the law doesn't authorize me to punch you. But I can do anything else that is not a violation of the law against you, such as call all my friends, start protest around you, leave. I can do that. So long as it doesn't, I don't know, doxing. So long as it doesn't violate a rule, that is my liberty too. And that is a liberty-liberty relationship. What the law does is it might codify certain constraints on the remedies for a spying operation, including abusive ones, and it will generate the kind of remedies you are typically allowed to engage in. So another example of that is spy swaps. We technically have a criminal, the formalists like to cite to me, see, there's no state practice in opinion yours going in the same direction because everyone spies, yes, but everyone criminalizes spying too. So no one is saying that it's lawful to do it. But wait, everyone criminalizes spying on them. That's what they're criminalizing. They're not criminalizing spying on others. They're criminalizing spying on them. It is that the law had authorized you to do what is in your power to prevent spying on you, and one of those tools is criminal law. And the fact is that in many of those cases, there are then negotiations through diplomatic channels that then evaporate the criminal process, whereby the swap of two spies is done to evade the need to actually achieve the actual legal retribution. And so it's just a complex thing about absorbing and remedying these problems. And last thing I'll say, and then I'll take it. Last thing I'll say, it's also a unique prescriptive process. In typical rulemaking, we have countries coming together to face a problem, and either they go about it by creating a treaty or they set resolutions, and there's processes. The problem with espionage, especially espionage mediated by technology as technology evolves, is that much of that activity begins in secret and revealed later down the line. So there's delays on the ability to engage in prescriptive activity. And what happens typically, I equate it in my book to breaks in the matrix. Every now and again, there will be a break in the matrix where spies are everywhere. We just don't see them, except when there's the break. And then we can peer in. When there's a FOIA request, a Snowden revelation, investigative reporting. In those moments, there's an opportunity for an enhanced, what I call constitutive process, an enhanced process to regulate particular conduct in real time because there's a consensus. So when the United Nations General Assembly resolutions on the right to privacy in the digital age were formed after the Snowden revelations, ultimately leading to a special rapporteur on the right to privacy for the first time at the Human Rights Council, those are all prescriptive consensus building in a particular moment in time shaped by a scandal. And it is those, it's just a very unique kind, some would say maybe very normal to international law, that is constantly reactive to crises, and yet still a very unique kind of reaction that generates thereby unique kinds of solutions, which I will too claim is part of this intelligence, international law of intelligence.
So thank you so much, Professor Lubin. My name is Joe. I'm actually one of the students on the Jessup team, so last years, pepper me hopefully tomorrow. So the two things I wanted to ask you about were the things that you kind of put aside at the beginning of your conversation, namely the relationship to kind of non-state groups and the relationship to kind of covert action. So why is it appropriate to sideline those things, given the ways in which, in different historical moments, different countries, it might be that the covert action side of intelligence agencies is kind of the tail wagging the dog, so to speak.
Right. So to be sure, I'm not wanting to sideline. Rather, I want to start with an easy case and go to the harder case. And so the problem is that we don't have a law on the easy cases yet. And so I try to build it and then apply it to the harder cases. But since we're here, I'm not going to cop out. I'm going to start talking about the harder cases. So let's just start first with your first question and then the second. So non-state actors. One thing the book does talk about is delegation, to the extent that there is a liberty to spy, a liberty limited by the liberties of other states, to engage. That liberty is governed by here under the jus ad explorationem. It's limited for certain purposes under the doctrine of abuse of rights. So you can only spy for national and international security. Notice national security is a broader category than just self-defense. And so, for example, say if you're spying, one of my favorite stories, the Czech Republic prime minister was having an affair with his chief of staff, and she really wanted him to divorce his wife. And so she sends 2 intelligence officers to go after her every time she's in international travel, in trying to find some dirt that she could then show the prime minister. When it was revealed, she was tried and imprisoned. And the judge says in that case that you abused the sovereign national power to spy, because you use it to advance personal interests. So that would be a category of activities that you are not allowed to. But once we've established a liberty to spy, now we can delegate it upward or downward. Now a state can delegate it to an international organization or delegate it downward to non-state actors, but under constraints that are tied to the same set of prescriptive rules. And a core constraint for me is that there must be particular areas of inherent governmental and sovereign functions. There has to be particular things that cannot be delegated. Part of the problem that we face today around corporate activity in cyberspace, in surveillance, PMS, private military security companies that are now engaging in surveillance and AI and cyber, all of that is that we have delegated too much of the intelligence function of the state, a core sovereign function, to actors who are not beholden to the public in the same way that the government is as the entruster of public values. And one core example of that, spyware. The fact that we are now delegating vulnerability hoarding in software to commercial actors completely evaporates the whole concept of equities process, which we have here in the United States, whereby the government is supposed to be the one who learns about vulnerabilities and decide if and when to hoard or to immediately share with the commercial sector so that they can patch it. The fact that we're delegating that to commercial actors who are beholden to different interests, more often will hoard rather than share, is a problem. Another example is called 9/11, because in 9/11, part of the problem at least was that we've contracted out the intelligence analysis part to contractors who were more interested in telling the president exactly what he wanted to hear about Iraq than what was potentially going on in facto in Iraq as it relates to WMDs. And so the idea that we are delegating analysis, which should again remain within the government sector, to private actors might be too much. So that is on the privatization. But I think your question, the harder question, what about covert action? There too, I have a beginning of an answer. So if the covert action is illegal, and part of the problem is covert action is such a robust category, ranging from misinformation on the low end perhaps, not mass misinformation, just misinformation on the low end, to assassination on the far end. If some of these are illegal, one of the arguments I make is that another abuse of rights is to spy for the purposes of committing an internationally wrongful act. So when Putin tells the intelligence officers, start spying on Crimea, because I'm planning on invading Crimea, and the invasion of Crimea is ipso facto a violation of international law, then what is also a violation on a kind of, you want to call it a fruit of the poisonous tree doctrine, under a basic conception of going upwards, then the intelligence collection, when it's done explicitly for that person with purpose, with that knowledge, must also be illegal. And so there's a limit on the kind of intelligence activities. And notice what I'm doing. I'm tying it to the purpose for the collection. And the thing that is so important about that is that it's a use ad claim. It's about when is it lawful to go to war? When is it lawful to spy? Contemporary international law of intelligence is not interested in that because the contemporary doctrine just tells you there's nothing intrinsic to intelligence to regulate. So we don't ask the why you spy. It doesn't answer all your questions. Like, is it lawful to assassinate? That's what I want to know. I think it's really, really, really bad. I don't think it should. I just don't want to make statements based on nothing, okay? Each of these needs to be analyzed on its own account. Now, Michael Reisman wrote a book in 1991 called Regulating Covert Action. And he too cops out. He spends, the conclusion of that book ends with 10 recommendations to the government lawyer faced with these questions. And he says stuff like, if you can do it publicly rather than secretly, you should do it publicly. If you can do it in this manner rather than this, you should do that. But it doesn't really get to the heart of what he was set out to ask, he and Professor Baker, is it lawful? And so, who am I if Reisman couldn't? So I'll just say there should be an independent study of those activities, but to the extent that the intelligence is aimed to serve those functions, and those functions are deemed illegal, then the intelligence that is in their service too. I'll just add one more thing. So Sophie DeRoy wrote a book, Regulating Intelligence Activities. She criticized me. She says, why are you separating? It's artificial to separate the intelligence passive collection from the covert action because they're both done by the same agencies, and any covert action will require intelligence collection. The Russians, when they put chemical material on doorknobs to get certain people sick and dying, they need to get intelligence about the doorknob. They need to get intelligence about the security apparatus around the neighborhood. That's all intelligence collection. And so it's all one and the same. And in fact, if you're trying to separate them, she says in her book, you are operating with some secret political motive. Because the intelligence passive collection is more justified, and so you're trying to justify it in separation for the less justified. I do believe that they are separate by the fact that governments don't always collect intelligence for covert action activities, by the fact that programs are called different names when they're for the covert action stuff versus the intelligence collection stuff. When they are interlinked, they should be regulated as one and the same. But when they are not, they should be regulated separately.
Picking up on that you mentioned, like what happens in the edge cases where, say, something is collected for a legal purpose and then used for an illegal purpose, or vice versa, collected maybe for an illegal purpose but then used.
So we have precedent for this because, for example, in the law of torture, what do you do with information collected by torturous means, and then shared. Should you, as the receiver of that information, be allowed to receive it? And human rights bodies have come out saying you can't, you shouldn't. You will be complicit in the violation, subject to you being aware that it was collected by those means. And so, can you, after the fact, just say, well, the information is now here, we might as well just use it? There is questions around complicity, which in part require us to imagine what the law of complicity is as applied within the lex specialis of intelligence law. But I do think that one of the biggest tools in that field is interagency pressures. So in order to enforce, this is not my words, in the works of Ashley Deeks from the University of Virginia, she talks a lot about how intelligence agencies enforce rules against each other in that secret cabal where there is no scrutiny from the outside. In order to ensure that I can use that power, to ensure that one intelligence agency tells the other, no, you have to get your act together, I need that intelligence agency to be told, you cannot benefit from the violations of another. And so for me, there is a strong logic against justifying later use of an otherwise legally obtained information. Did that answer the question? Yeah.
I have a question how your theory relates to the current state restrictions, because in the Nicaragua case, by the airplane over the Nicaraguan airspace, and then Costa Rica, the incursion of troops on the territory are qualified as what is now understood to be the rule of territorial sovereignty. So
beautiful. So
do you think that the rule of territorial sovereignty does not exist? And how does it relate to your theory?
Perfect. So first of all, let's just start. So there's a great book chapter by Inaki Navarrete in a book called The Research Handbook on International Law and Intelligence, which he co-edited, where he contributed a chapter looking at the entire case law of the ICJ. He identifies 7 cases where the ICJ engages in one form or another with intelligence. It's a terrific book chapter. He specifically talks about cases in which the ICJ seems to have affirmed that there is no lex specialis. There is just the rule of sovereignty, such as Nicaragua. On the Nicaragua front, I will say that the court is interpreting those incursions in a broader context. And the broader context is also identified by the court as a violation of international law. That is the non-intervention violations and the uses of force by the Contras. And so if you follow my logic, to the extent that the intelligence collection is done for the same illegal purposes, that intelligence collection would be wrong too. So I end up agreeing with the court's outcome, but just for a slightly different reason. Not to look at the sovereignty violation by itself as the end-all, be-all of the analysis. It is a problem, but it's further not rectified, but rather is further deteriorated by the fact that it's also serving illegitimate means. I think that the bottom line, the law of sovereignty to begin with, has always been a complex space. To try and speak of pure sovereignty, as Kevin John Teller does, is a bit of a facade. It's in Michael Wiseman's words, it's a myth system. There is no pure sovereignty. We are constantly engaging in an interactivity of the kind that intrudes upon sovereignty all the time. And so I'm not willing to put sovereignty on a pedestal. I'm willing to understand it and its important role in a Westphalian order, but accounting for other factors that equally play a role in that understanding. And perhaps a different way of speaking is to accept that law is a more complex feature than just the full book. And so ethics, norms, political pressures, economic pressures, well, unless it calls code, okay? If code is law, it's partially because code is just another normative power in a space in which we're trying to set expectations of behavior. And all of these set expectations of behavior. And so there's no reason to put the formal rule on some different plane than the other equally shaping behavior rules out there in the ether. That is, again, very non-formalistic account, but I think the right account to think
about the frontier between national security and national interests, because I think many times during peaceful times, it's about industrial espionage, actually. It's not directly linked to avoid a war, prepare for war. Like you have the US state spying in some process to give advantages for some specific US companies in international competitions. And sometimes it's against a Chinese company, so it's make easier. But other times it's about a French company. Talk about specific real case like in Brazil, we had some licitation for satellite services between French companies, US companies. So how is this law, especially when the US is favoring one specific company of the that is US based, not other US competitors?
Great. So the question is about economic espionage. When is it lawful by one country to steal the intellectual property of another? We may recall that Obama and President Xi came together for a brief moment and signed an agreement that says that the stealing of intellectual property is a violation of international law and that it will not do it. And that was actually followed on by the G7 making a similar communique and the G20 making a similar communique. And then, of course, lasted only until the Trump administration came into power and then forget about it. And then we saw another new spike in spying for these purposes across the board. I think the answer starts for me by asking again, what would be the justification to spy? And if you're limiting the justification to spy for national security and international security purposes, it does suggest that certain categories of spying to advance national security could involve the stealing of commercial assets. I am not of some absolutist ideal that concept has to be outside the board, but it cannot be anything. And so it cannot, it has, there is a line, and the line is very hard to define, right? But I always start with the easy cases, like the one where this woman is abusing her intelligence for personal gain. So if you're spying to advance a corporation, so for the sole purpose of gaining more money for the budget, that's not a legitimate reason. The example I give in the book is about how we discovered canned goods. The British were really concerned that Napoleon's army will advance. And one of the ways that Napoleon came to do it is to put a lot of money on new technological advancements that would support the military. And he thought that someone will develop new weaponry systems and solutions. No, someone comes in and says, I have a solution, a can. And the idea was, we can feed the front lines with things that will stay good for them to eat for a long period of time. The British put a spy who collected information about the canning powers of the French and advanced the canning industry that ultimately grew much stronger and bigger than the French. Here's a perfect example for me for a commercial spying activity that is inherently in the national security interest. And so for me, that activity is not outside the scope of the legal process. I think that it gets more tricky in the age where AI races across the board, and AI is such a complicated thing. What of it should be or shouldn't be legitimated for intelligence gathering activities? These are hard questions to answer. But I will say, just to end with that it's a hard question for the legal system as a whole. You know, the law of self-defense speaks of the right of self-defense against an armed attack or an imminent armed attack. And part of the challenge is, how do you define the contours of what an imminent armed attack is? We have a lot of definitional problems existing within international law. And if I'm building an international law that mirrors a pre-existing one, I'm going to import a lot of the legal imperfections that the existing law system has. So I'm definitely importing some of them into my systems.
Asaf, thank you for the brilliant presentation. It's funny, each time I hear you, I feel like this is a threshold when you surpass it. So this is, I mean, you know, it's field building work. I love that you've drawn law out of the shadows. I'm going to ask you a question that is not actually within your project, so you can't reject it. I just, so this, well, it's a two-part question. I've become one of those people. One has to do with, it's just a commentary thing, is I'm curious, so this has to have connections with power and resources, of course. You're describing, you know, China, very powerful state with access to resources, spying on the African Union, which would not be able to do reciprocal spying just because it can't. And so one is, I'd be interested to hear your thoughts on what that difference means. I know it exists in war as well, but I'm just like curious about the state of thinking on this. The second is like widely outside your project, but I love that you've picked out the law of spying from the shadows, from what is allowed. It tells you what is not allowed. And that has to do with kind of the external relationships. But it occurs to me that a spying agency would both develop norms that allow it to comply with the external rules, but also have these internal, almost like professionalized norms that have to do with the state's internal understanding of sovereignty, as you described so beautifully just now, what's okay, what's not.
Mhm.
Maybe some states feel like it's fine to like spy on the doorknob. You know? And so I'm also wondering whether there's anything emerging on like a professionalization and where that comes from in such a shadowy industry.
Both of those are excellent questions. I'm going to answer both of them. So I'm going to start with the first one because it's about power, and it's a huge part of this project. So I'm going to tell you one of my favorite spy stories of all times. It's 2004 in East Timor, a new identified state who for the longest time under colonial rule, first under the Portuguese, and then there's a brief 7-day independence, and then they're taken over by Indonesia. And then in 2001, they finally gained some sovereign independence. And they want to build a presidential palace and cabinet offices to commemorate their independence. And so the problem is they don't have the big shot architects that can help them. So they reach out to Australia and say, Australia, why don't you send an A team of contractors who will help us build this cabinet office? And the Australians say, okay, mate. I know that was my attempt. What they don't tell them is they put 2 agents from the Australian Secret Intelligence Service, the ASIS, into the A team. And they build this Australian-funded renovation of the East Timor's cabinet offices in Dili are built with installation of recording devices into the walls. You can already ask yourself there, and I put it on the screen for a reason, why is Australia spying on East Timor? And the reason is because there's gas in the East Timor Sea, and they're aware that there's gas in the East Timor Sea, and they're worried that East Timor will find it first. And so what happens, they do find it first, and they get so excited. The only problem is they don't have the resources to extract the gas from the bottom of the ocean. So they reach out to Australia, say, so why don't we sign an agreement whereby you agree to extract the resources, you'll get a small share, we'll get the rest, win-win. Australia says, sure thing, but if you don't mind, let's negotiate the conditions of this agreement in your newly built cabinet offices. And for the next 3 weeks, every day that they leave the offices, they're listening in and bettering their negotiation position for the next day. So much so that by the end, the East Timorese agree to a moratorium, not searching for any more gas for the next 50 years, and giving some 60% of the revenue to Australia. In 2011, a Snowden-like fellow, Witness K, comes out of the intelligence community of Australia and says, enough is enough. I have to come clean. East Timor, we spy during trade negotiations. The East Timorese get enraged. Friends don't spy on friends. We're going to sue you. Because there's a clause in the Certain Maritime Arrangement Agreement, the CMAT, that says that any disputes concerning this treaty goes to the Permanent Court of Arbitration. There's only one problem. You see, East Timor doesn't have the big shot lawyers that can represent it before the Hague. Thank God Australia's just across the pond. So they reach out to an Australian lawyer. At this point, Australia's like, this is too easy. They start spying on the lawyer. Day before proceedings are supposed to commence in the Hague, they get a court order for national security reasons to seize the passport of Witness K, who's supposed to testify at the court about what he saw. Timorese getting enraged again. You spy on our lawyer, we're going to sue you again, this time in the International Court of Justice. And for the first time in East Timor's history, they realized maybe we can get a non-Australian resource. So they hire a British lawyer to represent them. And the ICJ issues a provisional measure decision on the seizure of documents case, in which it says that spying of the lawyer may, just may, have violated international law because it violated the attorney-client privilege that exists between the state and its attorney. It is at that point that America steps in. Because you see, we've been spying on lawyers and during treaty negotiations for years. We don't need an ICJ case coming out saying it's illegal. And so we tell the Australians, you do whatever you need to do to disappear these cases because before there's a final judgment on the merits, which takes 3 more years of negotiations. The old CMUD is torn apart, a new agreement is signed, and both cases disappear. Now, side note, I know a lot about these from what Michael Reisman, who follows all the rules, but what he could share with me as one of the 3 judges in the Permanent Court of Arbitration case on the Australia-East Timor decision. So that's what I learned about many of these cases. Why am I telling you all this? Because this incident is one great example of where one state is using its power to spy not to advance national security, nor to advance international security, but to advance its own personal interest against a post-colonial state for the first time seeing its one natural resource, seeking the aid of a power who had benefited from its colonialization over the decades. It is a grotesque violation of international law. And it is a great example why the existing law is inefficient, because it cannot even account for what made this violation so grotesque, because it does not speak about the power that is at the heart of the decision to spy, that is what this regime speaks of. And I'll just end with one more TWAIL point, because I love TWAIL. Here, one more TWAIL critique. The generalist account of intelligence tells you that spying of the kind that benefit the global south is wrong twice over. Spying from embassies is illegal because it violates sovereignty and the Vienna Convention, except that that's the only cheap form of doing so, the kind that the global south can benefit from. But what is lawful? Spying from a spy satellite. What is lawful? Compelling Facebook to release all their data to you, which obviously Facebook will do to a big America, but will not do to a small Mozambique. And so the countries who benefit from a legal regime that is permissive in some accounts are the countries with power and means against the countries without. A legal regime that accounts for the powers is one that is more attuned to recalibrating and equalizing. And Monica Hakimi has an article coming out in the Yale Journal of International Law. She says people, again, she's a very strong New Havenite who grew out of Michael Reisman's teaching as well. She says, people keep saying that the New Haven School is a school that meant to support American interests. That is, and again, I'm willing to say, maybe that's what it meant to be when it first was created, but it doesn't have to be. There can be a version of the New Haven School that is about emancipatory projects, that is about empowering those who have not. And so hopefully that is the kind of account that I'm telling. So that's on the power. And I forget what your second question was, I'm sorry.
The norms within, the ones that are not in response to external norms. But if there are other questions, I can hold in and like you should talk to.
So I say it.
So there's one set of norms which I feel like you beautifully pulled out from what.
Oh, the fragmentation of the industry. Okay, so the intelligence studies community is very clear that this is a professional industry. Part of the justification for calling it a lex specialis regime is because it's a professional industry. I have a book chapter about negligent intelligence and how we can learn from the law of malpractice to create obligations on state to produce negligent intelligence. This is a professional industry with professional codes and a long sea of acronyms and standards, ethical professional standards on what you do. When are you allowed to release intelligence to advance certain purposes and keep certain intelligence not released? How do you create grievance mechanisms to report upwards when there's abuses of power? It is a professional industry. The international law people who are currently studying intelligence from a formalist lens don't talk about the professional practice because it's an internal secret practice that is at best guided by internal memos and non-binding memorandums of understanding between agencies. And yet, if one actually studies them, and many of them are publicly available, if you just care to look, or interview, or talk, you will, or read the books written by former intelligence professionals who then account for what they've done in a growing, sprawling intelligence studies community, you will start to see trends emerge. You will start to identify, at best, what I'll see called particular customs that are unique to a particular practice following community, an industry, a professional practice. And so a lot of what I'm building on is not just the ethical norms of moral philosophers, it is also the professional standards that these intelligence agencies all abide by, like the basic rule of efficacy. No one wants to spend a lot of your budget on intelligence projects that fail. And so I'll tell you another, because I have only stories to tell. This is a famous story. It's about the CIA. So weeks before the Abbottabad raid on Osama bin Laden, there was a lot of uncertainty inside the CIA about whether Osama bin Laden was even in the compound in Pakistan, and it prompted a risky attempt to obtain confirming DNA through deception. In early 2011, the agency recruited Shakil Afridi, a Pakistani health official, to run a fake hepatitis B vaccination campaign that would provide cover to access the compound. Afridi staged an irregular drive, first in the poor neighborhoods, then going to the Bilal town where the compound was located, and then he sent a nurse into the compound. And she was instructed to vaccinate the children of Osama bin Laden for polio. And then in the process, Sama also pick up blood samples, which the CIA was planning to compare to Osama bin Laden's sister, who died in Boston, whose remains they had, and so to determine if he's there. Now, you don't need to know anything about espionage to know how ridiculous of an operation this is. The most wanted man on the planet will just willingly open its doors in the most secret compound on the planet to a nurse to vaccinate his children. And then in the process, she's going to say, by the way, it would be helpful to get some blood samples. And she's going to take it from his children. To do that, insane. Needless to say, it didn't work. No, she got nothing. Not only did it not work, and by the way, she was not even clued in. And so talk about deceiving your own agents. But not only did it not work, once it was revealed that this is what happened, 60% of families in Pakistan refused to vaccinate their children for the polio, saying it's a Western hoax. So much of the 14 deans of medical schools across the United States sent a letter to then President Obama saying, you must commit to never again engage in an unofficial cover involving a medical operation, which the following year Obama publicly did with a CIA memo that went public. I don't know what the law is since, but what this demonstrates to me is an example again of a basic standard. The reason this operation is illegal isn't because we violated the sovereignty of Pakistan. The reason this operation is illegal is because we engage in something that could produce so disproportionate of a harm with zero chances of success. That is the reason this operation should not have been authorized in the first place. And by the way, once you think about that logic, you start to read about what people have said about the SolarWinds hack, a major cyber attack, some argue the world's biggest. People started to say what made SolarWinds so ridiculous. This is a Russian intelligence activity against SolarWinds, a company that produces network monitoring solutions, 18,000 victims of the hack through a patch that they push. The patch had the malicious code in it, the Sunburst code, and that resulted in the Russians having access to a lot of government agencies, not just within the United States, but around the world. What they said, what people like President of Microsoft, Brad Smith, said, is that this is a moment of reckoning. It's not espionage as usual, because there's something about this that is disproportionate of an attack, targeting the supply chains and so on. If you think about the CIA attack in the context of the SolarWinds attack, there might be a way to tell a story about targeting critical industries of trust. We need trust in our vaccination programs for the world to survive. We need trust in certain categories of emergency response in cyberspace, automated patch sending in cyberspace, network monitoring in cyberspace, so that maybe, and I'm not here to decide if, but maybe certain categories of intelligence activities in this domain too should be off the books. That's it.
Honestly, thank you for visiting and for your utter work. It's so good having you back.
Thank you.